busy week. We had a lot that we covered today, this week, but we're not done yet because there's more today that we're going to get into. And we've got some Fani Willis stuff. It's been a little while since we've had Big Fani house, but you know where she was not today? In what house she was not in? The legislature in Georgia, because they had a Senate hearing today. They sent Big Fani a big subpoena and she did not show up. So we're going to show what happened there today, and we've got a bunch of stuff to get to. So let me give you a preview on what's coming up here on the docket. So we're going to talk about Trump's defense attorney and his celebration / reaction to the news that Judge McAfee came out with a new order. Judge Scott McAfee is now going to be getting rid of some additional charges. You see, these are for two other co-defendants in the RICO case, but it also impacts Trump, and so they're very happy about this. More charges are going bye-bye in Big Fani's big, terrible case. And she also didn't show up to court today, or didn't show up to testify today, despite the fact that she got a subpoena. She was supposed to be there. And so it's very strange. You know, if Republicans ignore subpoenas, you get a Peter Navarro situation, or you get a Steve Bannon situation, and they go to prison. But if you're Fani Willis, or if you are Merrick Garland, or any one of those people on the left, then you can just ignore subpoenas and not show up to the Senate hearing. We'll listen to what happened there, and we'll see what the repercussions are, because basically they should, I would imagine, hold her in contempt there, in contempt of their Senate, and then defer her over to the state attorney general for some criminal charges, right? Is that what's going to happen? Well, we'll see. We'll poke through the hearing. The hearing was going on this morning, and it would have been a lot more interesting if Fani were there, but we'll hit some of the highlights and we'll see what is cooking. We've got a nice opinion to read through from Judge Scott McAfee, and so this one's pretty fresh out of the oven, and we're looking forward to going through that. So our latest Fani update as well. And another big story that's dropping today that we're going to really parse through is this organization called the NALC, which is the National Association of Letter Carriers. Those are your postmen and women out there, and whatever else they identify as. And they are Tim Walz. Isn't that so curious? So in other words, the people that are going to be showing up outside your house and picking up your ballots are now coming out and full-throatedly endorsing Kamala because of reasons. We'll read through it. We'll see what they said about this, but it almost feels like that should be kind of a conflict of interest. They are literally the people picking up your mail. And so if they show up to your house and you've got a MAGA sign outside, well, that's not going to be good for you. The post office, oh, this is a ballot. Oh, we'll put that, oh, MAGA, put that in this box. Oh, Harry Walz. Oh, we'll put that in this box over here. And they're coming out and endorsing Kamala. So that's just wonderful, isn't it? We've also got some other updates on the debate, because a former top Clinton advisor is also now asking questions about the debate, wondering why the debate felt like it was very scripted, and that we heard a lot of what felt like canned, pre-planned answers. And ABC News is saying no, there was no giving of the questions. Don't be ridiculous. There's no history of this, you know, unlike what we saw, for example, in the prior debate with Hillary Clinton, where Donna Brazile gave her the questions specifically. And so that is a conversation that is being had. We've got some other debate highlights, right? They're all basically lying in the aftermath of the debate, saying that Trump made up a bunch of stuff when in fact he did not. It's all true. And he was being fact-checked with fake fact checks. So we'll talk about this Abdul fella, and then we'll talk about this abortion stuff, because the Democrats have really flipped on abortion. We've got these clips from Clinton and old Joe Biden when he was the different version of himself that you see there. Didn't even look like himself.
Go back to straight, man.
They had a perspective on abortion.
Get your rest.
Shifted, and Kamala was out on the campaign.
Thanks for dropping in. I appreciate it.
Interesting, right? So she really, we were wondering where that cackle was, where her laugh was during the debate. They really suppressed that. I don't know if there's a drug for that. Maybe Pfizer has a shot for that or something. But it's like cackleitis, Kamala cackalatitis. That's what it is. Cackalatitis is what it is. So maybe they gave her a shot immunize her against her cackleitis on the debate stage, but she wasn't cackling at all. But then when she goes out in front of the world, she's cackling all over the place. And so we have this clip here. She looks like a crazy person. So shout out to her for keeping that under wraps. But there's some more news. Also, the criminal stats have now been released, and you see Trump is right, okay? Since he left office in 2020, crime has gone up. You can see it right there. And these are even on the back of the rigged numbers. This just came out September 2024, U.S. Department of Justice, crime stats going up. You see it right there, as the chart shows. Charts don't lie, I guess. And so Trump's people are sending this all over the place, showing crime has gone up. We'll see if there's a fact check there. And we're going to talk about some other polls and other reaction to the debate, because it is still percolating. Nate Silver had some interesting stuff for us, and ABC News, as I said, was responding to the claims of giving Kamala the questions. And so we've got a bunch of good stuff to get to, my friends. Very grateful that you're here and with us today. Thanks for joining us on the early show. We are out and about. We're in Prescott, as we said today, so this is a new location, new scenery. As always, thank you so much for supporting our show. Thank you so much for subscribing wherever it is you're watching this, inviting a friend or family member to come over here, check out the show, because there's a lot of watching that needs to be had between now and the election, and we're going to keep our energy levels high here and keep the spotlight shining down upon our system. So thanks for being here. Thanks for subscribing. Thanks for liking it. Thanks for sharing the video with someone you know or love, because we've got business to attend to here. And so let's get right into it, because we've got some Fannie news in the House. Donald Trump and his defense team are celebrating because Fannie Willis lost another one. You see, this is Trump's defense attorney, Steve Sadow, who we saw as the pit bull in Georgia back during the disqualification hearing with Fannie Willis, when she was in big trouble because she was indicting her lover and paying him $700,000. And so they were trying to get Fannie off the case, and that is on appeal. This case is kind of in a definite hiatus mode, but they're still fighting. They're still duking this out. And so we're battling against two other counts in this RICO indictment. And what Sadow says is, here's my comment about what happened out of Fulton County and Big Fannie's case. Says President Trump and his legal team in Georgia have prevailed once again. The trial court has decided the counts 15 and 27 in the indictment must be quashed and must be dismissed. And this came out in a nice order from Judge Scott McAfee. And so let's go through this. You'll notice it's fresh out of the oven for us, filed out of the state of Georgia, Fulton County, Big Fannie Willis in charge. And you see this involves two co-defendants that are part of the RICO case. John Charles Eastman and Sean Micah Tresher Still. Two co-defendants. Trump's name's not on there, but he's just one other co-defendant in this case. And as we're going to see in this opinion, this order is going to be big enough to say the charges that Fannie brought are illegal. She doesn't have a basis to bring those charges. She is a partisan prosecutor. She's a hack who's trying to take out her political opponents in the middle of an election. She hired her lover. They lied to the court about their love and their relationship. And they grifted $700,000 for an unqualified individual to participate in this case. And they did it to prosecute Trump. He was getting rich prosecuting Trump. If he would have turned around, if any one of them would have said, you know, these charges are illegal and they're going to be dismissed, they couldn't have brought the indictment, and they wouldn't have been able to make a bunch of money, like $700,000, while Fannie Willis was traipsing around the United States, traveling to California, to Napa Valley, and splitting stuff with cash money, drinking Grey Goose in Belize. Ridiculous. So anyways, we're back. Now, order on Trump's motion, or this is, we're going to call it, we'll just say Trump, but it's, I mean, Trump is the prime mover, right? Trump is the kingpin. Trump is the mob boss. Trump is the main one. So these are a bunch of other lawyers, so shout out to Eastman and Still. We're filing this on behalf of their clients. Trump's getting the benefit. But this is really the Trump case. I mean, these people are involved because of Trump. So they say defendants seek dismissal of the indictment. This is Trump and the co-defendants, based on the supremacy clause of the United States Constitution, meaning the feds override the states, which totally stinks, but it's in there. They argue that the indictment is preempted by federal statute. So there's some other U.S. code. Fannie is taking some federal right away from the feds, and she can't do that. The feds preempt Big Fannie. saying that presidential electors fall outside the state's appointment power and police power. So we're going to ask ourselves, right, if this is going to be a persuasive opinion that might be not binding on the other criminal prosecutions happening elsewhere, like, for example, in Michigan and Arizona and elsewhere, right, where Trump has not been indicted, but they are going after the presidential electors. So is this going to immunize them? Saying that state action, the state is prohibited because the subject of the indictment is inseparably connected to the national government. So she's prosecuting, in other words, federal crimes. Saying that John Eastman, who we have a clip from coming up, also is adopting these motions. Trump looks like they're adopting these motions, and so everybody's kind of adopting these things, okay? So he's given us the procedural history. Everybody's taking these positions, and here's some procedural background. They say on June 5th, the Court of Appeals sua sponte on their own. So the Court of Appeals just, they were kind of just hanging out like, oh no. They issued a stay of all proceedings saying, all right, this is a big problem. In any case, direct request, the Court of Appeals also granted, we want to keep going. So we'll come back on that. Now, the court heard oral arguments, and after considering the briefing, the court finds that the indictment is not barred entirely, okay? So it's because the court also finds that the decision of the Supreme Court in Ray Loney preempts the state's ability to prosecute perjury and false filings in a federal district. Co-defendants, Eastman and Still, sent in stuff to a federal court. And Fannie is saying, whoa, you defrauded a federal court. And I'm going to charge you with that here in Georgia, in Fulton County. Wait a minute, you're not a federal prosecutor, Fannie. We know you think you're the biggest Fannie in all of Georgia, and exactly you are, but that doesn't make you a federal prosecutor. You're as illegitimate as Jack Smith is. So she brought in federal charges, basically based on federal offenses. Now they're still saying that this indictment is also improper under officer immunity, okay, under presidential and officer immunity. So the defense is saying there may be more here. Like, there may be more basis and more to reach these issues, nor does it reach the immunity decision that came down from the Supreme Court, because we've not even fully briefed or argued these. And the oral arguments on this took place a while ago before the immunity decision came down, which was this year. So I was like, look, these charges are gone now, but we might come back later and dismiss the rest of them. So here's the basis for the opinion. They say, first of all, the Trump co-defendants first argue that after December 8th, 2020, after that time, any state action related to the presidential election was unconstitutional, and indicted offenses are now preempted because the Electoral Count Act is a federal law, and that details the federal Congress's voting process. Other states, I hope we do. Because election-related litigation remained pending as of that date, the defense contends that only Congress, okay, and not a state prosecutor or state grand jury, can determine validity. Why we have alternate electors in that process that was already in place. They did it back in 1960 with Kennedy. Georgia law presumes the constitutionality of its statutes, and so we presume that it's valid, and the burden lies with the defense to prove that there is a clear and palpable conflict before this court should declare any law unconstitutional. So you guys got to show it's very clear that there's a conflict here. Now, the constitutionality of a statute may be challenged by the defense in two ways. You can say, well, it's invalid on its face. A facial challenge can be more difficult to challenge because it requires higher standards. Now, although this wasn't discussed in detail, the court views their preemption argument from the defense as a mixed challenge, saying the claim is applied to multiple areas, and let's see some analysis. They say, first of all, Because it requires an explicit showing of intent, express preemption, meaning Congress says we are literally preempting you. Here, the Electoral Count Act from Congress, it does not expressly preempt state law. So we can't say it's an express preemption. Is it a conflict preemption? Well, it could be. Let's see what they say. It says it does not contain any indication that a slate of electoral ballots would be free from criminal consequences. So the law does not explain that, and the indictment also does not frustrate the purposes of the ECA. So maybe it doesn't fall into that category as well. So likewise, we don't see any alternative purpose here, and so absent any indication to the contrary, the court finds that the statute and the purpose of the law is to mandate, all right, a congressional process for counting the votes. That's it. It's a process and nothing more. So there's no criminal penalties. There's nothing else in there that it dictates. It's just a congressional process. Got it. So now the defense then argues that by removing any reference to alternate slates of electors, the amendments show that the alternate slates of electors were authorized, right? So remember, they came back and they passed the Electoral Count Act after 2020. They said Trump made up a bunch of stuff. Mike Pence doesn't have the power. He can't do this thing and this thing and this thing. And we said, well, he actually can. We think he can. We don't know if there's good logic to that or a good basis for that. But it doesn't say he can't, and it doesn't explicitly say he can. But it does. There's an argument for it. And so what happened is they says watch your step there. It's probably because somebody tripped and fell and the steps are out of alignment, so they put a warning there, or they fix the step, right? Let's say you have a problem in your business. It's a problem. You recognize that's a liability, so you fix it, which means that thing could have happened, right? That damage could have potentially happened, but you remediated it. Now it's not exactly the same because in other words, they're saying this was a possibility. Like this thing could have happened. You could have slipped and fallen on that thing, and we fixed it. And so now Trump is saying, well, we used that opportunity. We didn't exploit anything. It was the law, right? That was an opening. So they say now they change amendments also do not imply requirement, right? It didn't require alternate electors, and it didn't offer immunity to those that did. And so the amendments were made in 2022, over 135 years after the initial passage. And as the Supreme Court has noted, the views of a subsequent Congress form a hazardous basis for inferring the intent of another one. Right? Congress is fickle. But still, the defendants raised two hypotheticals that could frustrate this purpose. They say, the defense, Trump and the defendants say, that if Congress had hypothetically accepted the slate under the ECA, and the judge says perhaps, maybe, but this is not the scenario that occurred here. And for the purpose here, the court doesn't have to go into hypotheticals. Now, Congress only accepted and counted the electoral votes certified by Governor Kemp, not the alternative electors. And so second, they also contend that there is a conflict because after the safe harbor date, the determination of valid electors is an exclusively federal issue. And so Georgia and their certified slate of electors was not conclusive under the ECA because there was litigation under effect. And so in this way, they say that the indictment could be seen to frustrate Congress's purpose as well. But the judge says this is not conclusive. All right, look, in short, the function of this is to prescribe Congress's process of counting the votes. Thus, the court concludes the state's prosecution is not barred by conflict preemption because it does not impair congressional vote counting as prescribed by the ECA. And finally, the court cannot find any support that Congress intended this to preempt the entire state criminal law field about elections, right? It's not a criminal statute, so the state does have some power. So the judge is getting rid of all the stuff that doesn't apply before we get to the stuff that does apply. Now, as we fast forward, he says, in summary, the court finds the state's indictment is not preempted, right? The entire indictment is not preempted by the Electoral Count Act because it doesn't expressly preempt state law. It doesn't create an impossibility of compliance. So, in other words, you can charge somebody, and there can be compliance. The indictment does not obstruct the fulfillment of the purpose, and it does not exclusively occupy the relevant field. And so, to the extent that they want to dismiss the entire indictment, not going to do it. Now, while the defense may have believed themselves to be acting lawfully under the ECA, the intent cannot be examined right now, and this order does not reach the merits of intentionality at the trial. But then we get into the appointment power. Now, outside the traditional preemption context, they also argue that the indictment of these unelected federal electors lies beyond their grant of power. So it's not about the ECA or supremacy per se, but the state can't impede on the appointment power that's in the U.S. Constitution. So the argument relies on another Supreme Court case called U.S. term limits. They explained that this is the rule, that the Constitution says that states get to prescribe the time, place, and manner of elections for members of Congress, as well as the power to appoint presidential electors, delegated powers to the states, while the 10th reserve the rest of them. So any additional exercise of power within that framework must be delegated to the states by the Constitution. And so after consulting these cases...
Be right back. fuel up for our trip next week to West Virginia. So I don't know when I'll have time to run back up here before we go. Got some little goodies, little pain relievers.
This indictment is within the state's power, saying that the state may prosecute a person for fraudulently voting for electors in the Electoral College and so on and so forth. So we're going to keep the entire indictment. But then we're going to get to some inseparable problems. So this is the problem now, ultimately. Now, finally, the defense argues that because the election of the President of the United States is inseparably connected to the functioning of the national government, the Supremacy Clause bars the indictment. They rely on this case, in re Loney, which prohibits state prosecutions for perjury related to statements that a defendant made while testifying in federal.
You got these little seltzers, watermelon flavored seltzers with 7.5 milligrams
So that Supreme Court case says that when a witness is
of medicine.
under the federal level, they provide testimony in obedience to the federal laws.
So I'm gonna try one of these.
Now, similarly, in another
Good, I'll
case,
grab
the
some more
Supreme
before we
Court
leave.
found that a state court did not have jurisdiction to defend for perjury when a crime is committed in the public justice of the United States. So, if you're lying to the feds, it's a federal crime, not a state crime. The court in that case based its decision on a federal statute which says exclusive jurisdiction is in the federal courts for crimes against the United States. And so now they say, after the state safe harbor date, Congress was adjudicating the validity of the presidential electors. So any action, right? Congress was now adjudicating this. So the defendants enacting as presidential electors would be barred from being prosecuted by the state. He says, we're not going to go that far. The majority of the indictment says that you violated state law, but there are 3 counts which say that you're lying to the feds.
No artificial sweeteners.
So
Made with real fruit juice, made with Michigan-grown cannabis.
In a federal judicial proceeding
Shit.
is it states with the feds. A federal preemption case saying states may not impose their own punishment for perjury in federal courts.
Fuck you.
So the central holding in Loney is about whether the feds can police their own proceedings. And so yes, they can. At the time of this indictment, federal laws have a mechanism for filing false statements made under oath. And so if you
God, I should have got a few of those.
count to a code. But here, it is in the Northern District of Georgia. Okay, so she's saying you violated state law, but the fraudulent filing happened in federal courts. And so it's a federal court. Federal law already exists for this. And so this charge must be quashed. So that one goes bye-bye. Similarly to counts 14 and 15, little different question, but now we're asking dual sovereignty questions. While the conduct under count 27 could be directly punishable by the feds, these charges say that false documents were mailed to the district court in violation of Georgia law. Now, also, they say this lies beyond the narrow holding, so can the state also concurrently prosecute the conduct like mail fraud? The doctrine of dual sovereignty holds that both the federal government has concurrent jurisdiction when it's against a crime is against both the state and the feds. And the judge is giving us several examples of this. The reasoning employed by this supports the conclusion. It's essential to the impartial and efficient administration of the tribunals that witnesses should be able to testify freely before them. So filing a document in the court is analogous to providing testimony. So counts 14 and 15 here interfere with the district court's ability to do that. They impose a state sanction when federal sanctions are already in place. So counts 14 and 15 must also be quashed. And so the other counts doesn't extend to the other counts. Now this one, right, because they also delivered stuff to the archivist of the United States. But they say the archivist is not quite enough. False statements to the archivist don't fall under perjury statutes. And so those will remain And this is basically more Judge McAfee being more Judge McAfee. Overt acts, this is finally, the quashal of these 3 counts does not affect the corresponding overt acts. Overt acts alleged can still be in the RICO indictment. So it's like death by 1,000 cuts. It's like, Judge, this whole thing should have been disposed of a long time ago. It's really just mincing words because Judge McAfee is in the middle of an election. All right, conclusion. The Electoral Count Act does not preempt any of the statutes invoked. The indictment is also within the scope of the state authority. Fannie can do whatever she wants, nor is the subject of the indictment so inseparably connected to the national government that it's barred by the Supremacy Clause. And he's not even addressing immunity yet, right? So this is like a year-old issue without even bringing in immunity into this. This feels very just circular, like we're just wasting our time here. And he's just doing a lot of academic, right? It's academic stuff, which I guess is important in law. But this case should have been dismissed a long time ago. And Scott McAfee continues to be the spineless judge there in Georgia. So that's the decision. Now, it is ultimately good news because Eastman has a victory here. John Eastman,
unusual to see an oversized load like this without a chaser and a lead car.
Corrupt interests. And so he was out in the aftermath of this decision, and here's what he said.
Here's what we're talking about. It's a decision from Judge McAfee down in Fulton County Superior Court that goes strongly against Fani Willis. It dismisses 3 counts, and those are 3 counts that were challenged by John Eastman and a state senator named Still.
That's Jeffrey Clark.
And then
Not John Eastman.
President Trump, as you noted, was a party to 2 of those counts. And so he benefited from the fact that they won the dismissal of those counts. President Trump and I and several others are up on appeal to the Georgia Court of Appeals, arguing that Fani Willis needs to be disqualified from this case and that Judge McAfee erred in not disqualifying her. That case is going to be argued in December. But John Eastman and State Senator Sean Still did not join that appeal for whatever reason. And so Judge McAfee issued this decision kind of grinding through their motions, attacking the indictment. And here, let me explain to you what's going on in terms of what got dismissed. So a little bit of, I guess, Clark Law School class for the War Room audience, but it's a sophisticated audience. There's an area of federal law called preemption, which is based on the Supremacy Clause of the Constitution, and it says that federal law, supersedes conflicting state law or even areas where the federal.
That's Jeffrey Clark, and he's going to give us more analysis. We just read through the full opinion, but some good stuff from him. We also know Fani Willis, in addition to losing her case badly, being exposed with her lover stealing money from Georgia, is now ignoring congressional subpoenas. Is she going to indict herself for refusing to follow the law? So she plans to defy the subpoena. She did that today. Fulton County DA is not showing up. She got a pair of subpoenas, and she skipped the hearing. Her attorney said she's not showing up. Move is now going to set up a showdown in court where her attorneys have argued that the subpoenas are void because they were improperly issued and they were overbroad. She got a summons. She was supposed to show up there today in front of the Georgia Senate, and she did not. And here is exactly what that sounded like when Fani Willis was flouting the law.
The last person on our agenda, of course, is the first person, Honorable Fani Willis. She has not appeared yet. I would ask the doorman, please check the hall to see if she has appeared before we adjourn.
Yeah, she wasn't there.
Thank you. Then let's please note for the record that Ms. Willis has failed to appear in compliance with the subpoena and has failed to produce the documents requested by our subpoena for the production of documents.
Flouting a congressional subpoena from Congress in her local state. Now here's a little bit more. We'll listen to a little bit of this from the hearing. This is what it sounded like when it got started. Is she here?
According to press reports, she is defying her subpoena and not Legislative Counsel's office. If you look in your folder, you will notice that there is a memo that Legislative Counsel prepared back in 2016 dealing with legislative.
Yeah, they won't do nothing to her.
Administering oaths to witnesses and issuing subpoenas. So we're guided by their work and their legal advice. So I wanted Mr. Morelli to kind of educate the committee and the public on this process of an investigative committee as well as our subpoena powers. Following that, Mr.
All right, let's fast forward.
The case was not have been in the 2016.
No, and I'm going to provide some, information on this case. It is the Trump v. Mazars case out of the United States Supreme Court in 2020. In the Mazars case, the Supreme Court did provide that Congress has no enumerated constitutional power to conduct investigations or issue subpoenas, but we have held that each House has the power to secure needed information in order to legislate. They cited to a 1927 opinion of theirs, Bragg v. Dougherty. Mazar's case, the Mazar Court went on to provide the power of inquiry with process to enforce it is essential and appropriate auxiliary to the legislative function. Again, citing back to their 1920.
So they've got the power to subpoena Big Fanny, is what he's saying.
They went on again to state, without information, Congress would be shooting in the dark, unable to legislate wisely and efficiently.
Where you at, Fanny?
As I said, in 2020, the Supreme Court was citing back to its 1927 precedent holding Congress's power. State Supreme Courts have held the inherent power of their legislatures to conduct investigation going, I believe, as far back as 1824, when the Massachusetts Supreme Court, I believe, was the first state Supreme Court to address the matter. As I said, it has been a near universal finding that legislatures have this authority. The only dissent Thomas in the Mazars case. He did believe that the precedent relied upon by the Supreme Court and the other state Supreme Courts was misguided.
No Fanny.
No other justices joined in that opinion. Other state Supreme Courts have continued, subsequent to the issuance of Mazars, to continue to also uphold state legislative investigative powers of their legislature. I will.
Was that an 8-1 decision then?
Justice Alito did.
All right, so she should be there. Let's see if we get some other questions.
And as far as you're concerned, does that constitutional provision also apply to investigative authorities as set forth by Senate resolution? Make sure I remember the number. We have this in folders as well, 465.
I see no reason why that provision would not apply to a standing or a special committee as well.
Fanny should be there. There's more.
My hands on the Senate journals for the 1965 session, so I do not know what the report said. The 1964 resolution creating the interim committee to investigate Stone Mountain Memorial.
Okay, so even more. So they're laying a ton of foundation here, a lot, that saying Fanny should be there. Okay, we've got all this precedent. Supreme Court has said it. Georgia has said it. Let's continue to fast forward and see what else we got.
That's courts, when considering legislative subpoenas, in certain cases, with the in Mazar's case, the president need to show some heightened concerns to recognize the separation of powers. I was being a bad attorney and not giving you those sites.
You got a whole bunch of attorneys over there. You got a couple of non-attorneys that are as smart as you.
And I can provide copies of any and all of these cases to any members who wish them. The citation for Dean versus Bolton is 235 Georgia 544, and again, it was a 1975 case.
Where's Fanny?
Yes, sir.
Yeah. So even if it's not specified verbatim in our Constitution, our courts have followed the United States Supreme Court interpretations.
Is this whole hearing going to be about why Fanny is violating a subpoena? I love it.
Which were subsequently added, much more. I think in the early 2020s. The detailed ethics provisions that gives a second independent statutory procedure.
This is now a hearing about how subpoenas work in Georgia. I love it. The whole hearing.
All right, other questions? I would, Mr. Leader.
This will be short. Stuart, thanks for being here today. It's great to see you this summer. OCGA 5, 15, 17, and 19. When were they adopted into law? And
which governor was inside
into law, and I do have that before me if you will give me a...
Okay, we have another guy who's going to come testify, so let's see who this guy is.
And tell us what you're doing now in retirement.
I wish I could get to retirement. I'm almost there. My name is David Cook. I'm the former Secretary of the Senate. I received my law degree from the University of Georgia in 1982 and have been associated with the Senate actually going back to 1977. The Dean case.
I think it's a hearing about subpoenas.
In each house and may be exercised through a committee. That's Mason 795-11. So the creation of the committee, I think, was done in accordance with precedent, in accordance with statute, in accordance with the rules, but it was also done in accordance with our precedents. And Stuart touched on.
Okay, this is hilarious. So Fanny didn't show up, so their other witnesses are just people to say, these guys are just testifying about, one, how valid the subpoena is, and number two, how valid the committee is. So I love it. It's just like they're rubbing her nose in it. And they're doing it like total gentlemen. They're just kind of hanging out, just chatting.
What the Senate's powers are, not as restricted.
So they're pre-butting Fanny's objections. They're just doing it in public. She's saying, this is overbroad. This committee's illegitimate. You have no subpoena power. The whole hearing is just about how they do have the power.
Said from a legal perspective.
All right, let's see how it wraps up.
Under the attorney-client privilege, our rules do permit, I think it's Rule 5 of our committee rules, that a session that is closed, private conversation with our counsel to let us know where the litigation stands. Now would be the appropriate time to move.
Hold her in contempt for not being there.
Thank you, Mr. Chairman, for that. And I would move that we do, pursuant to Senate Rule 1-5.1, as you just stated, have this committee move to go into executive session for purposes of hearing from appointed counsel to advise us.
Is there a second? I have a second. Any discussion by committee members on the appropriateness of that or the desirability to have a private briefing? All right, all in favor of the motion, say aye.
Aye.
Any opposed? One opposed. All right, at that time then we will conclude the public portion of this meeting and we will stand adjourned as a public meeting. We will continue in a executive session to be briefed by our counsel on the current status of litigation concerning the enforcement of the subpoena.
All right.
Thank you. We're adjourned.
All right, so that's the hearing. So interesting. It was an interesting one, actually. It was very, what's the right adjective for it, but kind of in Fanny's face. Okay, here you go. Oh, you don't want to show up and be here? Well, we'll just talk about how wrong you are for a full couple hours with some very qualified people to do that. So Fanny's having a bad day, thrown in the middle of litigation, people asking questions why she's allowed to ignore subpoenas and flout the law, flout legal process in Georgia, while she then prosecutes everybody else, while her daughter is driving around on a suspended license multiple times. She shows up in t-shirts on a Saturday with Nathan Wade, probably after a night of indictments and Grey Goose, and now she's just, I don't know, probably on a cruise somewhere, maybe watching the thing on her phone. So we'll see what the Georgia Senate does with this. Hopefully we have some contempt proceedings escalating here very soon. We're going to be here to continue to cover this one, my friends. Thank you for joining. Thank you for subscribing. Thanks for liking this video. We would love to see you back here on the next one, and we'll see you back here when we do. All right, so we've got another segment to talk about, my friends, and this is another wild one. So surprise, surprise, this is the story. Big surprise! We've got the people who are going to be collecting the ballots in 2024 during the election. They just came out and endorsed Kamala Harris and Tim Walz. So when they show up to your...
Drive to Crust Pizzeria, White House, Ohio.
Sure, Crust Pizzeria. Let's...
need to meet her somewhere for dinner. Change my route a little bit.
When they see your MAGA sign, your ballot might be going in the dumpster. This is according to the NALC, the National Association of Letter Carriers. Who are these people? Well, you can see they work with the Postal Service. It's the Postal Service Union. They deliver mail in the United States and pick it up. We're career and non-career people. We work for our employer, the Postal Service. We deliver everywhere in the United States, 6 days a week. We're very, neither rain nor sleet nor snow nor shine. Your mail will be lost, whatever happens, and they just keep raising prices, and it's our mail system. But they are responsible for a lot of the mail-in voting, and so now they're endorsing Harrison Wild. Says the president is named Brian L. Renfro. Says we got 290,000 get-out-the-vote workers.
Looks like a state trooper.
Retired city letter carriers
got stuck over there.
NALC. We're proud to announce our endorsement of Harry Walls. The debate on Tuesday night reinforced what we already know. Kamala has a pro-labor record for illegal aliens, and we support the pro-worker vision for 2025 and beyond. Both have a strong history of fighting on behalf of unions and union members. Can illegal aliens deliver mail? I'm sure they can. California's giving them driver's licenses, so that's interesting, yeah. We know that Harris Walls will work with the NALC to address unique challenges facing letter carriers and the Postal Service. It's really hard work, I'm sure. And as a local prosecutor, State Attorney General, Senator, and Vice President Kamala Harris is a proven supporter of working families and organized labor in the Postal Service. As a senator, she was instrumental in advocating for the essential relief at the height of the pandemic, and so they just love her. So the people who are going to be collecting the ballots are now out in full force with a full throat, which is appropriate for the Kamala campaign, endorsing her.
All those in favor of the Executive Council's recommendation of approval, please signify by saying aye. Aye. The resolution and the recommendation of the Council has been adopted. The NALC proudly endorses
AJC.
the Harris-Walz ticket, and we will do all in our power to ensure that Kamala Harris is the next president of the United States.
We're going to do everything in our power to ensure that Kamala Harris is the next president of the United States. Everything in our power. So they'll just take your ballot, which comes from
don't mail in your ballot.
Drop them off, and they'll just throw it right into the shredder. Oh, he loves America. Everything in our power to stop Adolf. 290,000 active get-out-the-vote people now working for the Kamala team. Isn't that interesting? Isn't that very fun? Government workers who are just going to support big government. We'll see. Maybe illegal aliens can start delivering mail, and we'll see if their jobs are at stake, like the rest of ours. Hey, former top Clinton advisor calls on ABC now to launch an internal probe into whether the debate was rigged, since the border's rigged, the registering to vote is rigged, everything's rigged. The 2016 debate with Hillary was rigged by Donna Brazile. She admitted it. So, did Kamala get the questions? Top Clinton advisor called Mark Penn, because remember, Lindsay Davis admitted that she was a sorority sister with Kamala Harris. In fact, Victoria Taft published about this. Said moderator Lindsay Davis in 2021 bragged that they were literally sorority sisters. Here's that story. Here's what it sounds like.
Lindsay Davis, Robin Roberts is right. It's a sorority thing. I don't understand it all. So you have to explain it to everybody. You're a sorority sister of Kamala.
Right. Well, pearls are a symbol of Alpha Kappa Alpha Sorority Incorporated, which she pledged while she was at Howard University. The strand of the pearls is symbolic of the unity and the sisterhood, okay? But on this day, there's actually a Facebook page of women who say wear pearls on January 20th, 2021, and hundreds of thousands of women are apparently wearing pearls in support of her.
Yeah, they were all wearing pearl necklaces, remember that? And it was very curious that that was what they were embracing. But you heard that at the beginning. Sorority sister? What the heck was that?
Lindsay Davis, Robin Roberts is right. It's a sorority thing. I don't understand it all. So you have to explain it to everybody. You're a sorority sister of Kamala.
who's not a sorority sister of Kamala Harris like you are. Huh. Very interesting. So you see, we're asking about that. We also know that the woman, Walden, who was in charge of running ABC News, is, I guess, very closely related, actually works for the Biden-Harris administration as the export policy person. So a person working for Joe is in charge of ABC News. They came under significant bipartisan criticism because its moderators fact-checked Trump, so-called, with fake facts, but not a single pushback was made at anything that Kamala said. Felt like a 3-on-1. Penn told John Solomon Reports podcast, shout out to justthenews.com, says, I actually think that they should do a full internal investigation. They should hire an outside law firm. I don't know how much of this was planned in advance. I don't know what they told the Harris campaign. I think the day after, suspicion here is really quite high, and I think a review of all their internal texts and emails really should be done by an independent party to find out to what extent that they were planning on, in effect, fact-checking just one candidate, and in effect, less than that. He's exactly right. Could you imagine their text messages between what they're saying and stuff like that? I would imagine that there's a cover-up over there, too. I would bet that if you looked into this, hey, we want all your emails. Federal subpoena from some lawsuit or something from a judge, they wouldn't have anything. They were using Signals, the leading app. I mean, it was a hit job. It was an attack job, and they're getting away with it. Penn is the chairman of the Harvard Caps Harris poll, also said Harris has done a good job of defining Trump, but it's still a 50-50 race. In spite of all of this, Trump is still surviving and thriving. Other publications have disclosed the questionable coziness between Dana Walden, who's co-chairman of Disney and who literally oversees ABC News. New York Times quoted Harris, calling their relationship extraordinary friends, she said. She runs the news agency, and disclosed that Walden and Harris were neighbors in Brentwood, a wealthy LA enclave where Harris and her husband live. The Times also pointed out that the Waldens have donated money to Harris when she ran for DA in San Francisco. And so Mark Penn is not the only veteran Democratic pollster and advisor to criticize this. Doug Schoen, an advisor to Clinton and Bloomberg, lamented that Harris was aided and abetted by two ABC News moderators. Talk about a crime, talk about a conspiracy, who seemingly felt the need to fact-check virtually everything that Trump said. And so I think it's exactly right. There was a total scandal there, and they rigged it. But as we said that night, I think it's going to backfire on them. I think that a lot of people recognized it for what it is. They're bullies and they're cheaters and they're liars. Now, ABC News is responding to this saying, oh, absolutely not. No, we did not give any questions at all. Harris was not given any questions before the debate. Okay, were they talking points? Were they general topics? Were they categories? Did you guys give her categories? Did you give her statements? Right? I always get so sneaky with these questioning these sneaky words. She was not given any questions before the debate. Okay, what does that mean? Like the document you gave her didn't have question marks on it? Were they just talking point sentences that ended in periods without a question mark? None of Harris' aides were in contact with the debate moderators.
Make it home safe.
The point-blank denial comes after Trump, who said it was unfair and rigged. Someone else said, I watched her talk, and I said, she seems pretty familiar with these questions. In the lead-up to the debate, they had spelled out no topics or questions would be shared. And so even Democrats are saying, it's a little bit weird. We probably should investigate it. But they are in cover-up mode bigly. You can see this woman who really wants to beat Trump for some reason is making a lie to her dumb audience who just laps it up. And you'll notice that in 2021, they were talking about this guy called Abdul that Trump talked about during the debate. Abdul. Everybody knew Abdul. But then when Trump brought it up, no one knew Abdul anymore. And these people who are these like pseudo-Trump impersonators are lying to their audience about it. Here is the compare and contrast in the aftermath of the debate.
The man who now leads the Taliban in Afghanistan, Mullah Abdul Ghani Baradar.
Mullah Abdul Ghani Baradar, co-founder of the Taliban.
I could hear in Mullah Baradar's voice that he knew President Trump meant business.
CBS News has confirmed that CIA Director William Burns met secretly in Kabul with the Taliban's de facto leader Abdul Ghani Baradar.
We have learned that CIA Director William Burns traveled to Kabul for a secret meeting with Taliban leader Abdul Ghani Baradar.
A Taliban co-founder, Mullah Abdul Ghani Baradar, who oversaw the signing of the U.S. withdrawal agreement last year.
This is the part.
That was all the media talking about Abdul. Weird. Then we get the Trump impersonator who's trying to do the hair thing, and here's what she said.
Where Donald Trump invented somebody. He invented a person who doesn't exist in addition to the people he says are eating dogs. This is another person who doesn't exist. His name is Abdul.
And Abdul is the head of the Taliban. He is still the head of the Taliban. And I told Abdul, don't do it anymore. You do it anymore, you're going to have problems.
Maybe the reason that VP Harris is looking at him that way is one that she's probably thinking maybe he should go back to the old folks home and have a bowl of Jell-O. Or she might also think to herself, no. The head of the Taliban's name is not Abdul. It is Hibatullah Akhundzada. So maybe he couldn't remember that. You know, I had to write it down to know it. Your thoughts on his response in making up Abdul as a person that isn't real?
No one can really confirm who this Taliban person named Abdul is, who he said he talked to.
Bizarrest bit in the whole debate, where he describes the leader of the Taliban as a guy called Abdul. I mean, it's you know, it's completely non-existent, but isn't the one Muslim name he can remember. It's like, I don't know, the leader of the Taliban saying, that guy John, wacky directions she sent his head in.
Can you believe that they would actually, like, that's just not true, right? Their own people said the same thing. Abdul. So they're just shameless liars, and they just get talking. This is like a Muslim thing, so it's like they're going to try to create some Muslim community. Oh, he's just calling Muslims like Abdul, just like you call, like, you know, like Smiths or Johns or something like that. So it's really just shameless, but that's who they are, and they're all laughing about it, right? They all know who he is. They know exactly who he is. They talked about it. They reported on him many times.
Park.
In fact,
She just turned her car off.
So they know who he
All right,
is.
guys, I'm gonna end this.
On the abortion
Peace.
stuff.
I'll see you guys later.
Clock before the Democrats
I'm out.
went even more insane than they've always been.
We're eating dinner.
Hillary Clinton talking about abortion and how